very soon. All right. Well, good morning, everybody, and welcome to EDPNC's May Export Coffee Talk. My name is Blake Jackman. I am one of the international trade managers here at EDPNC, sitting in for Melissa McGurk while she's on vacation. Today's topic we'll be discussing is international intellectual property management. But first, I'd like to go over some housekeeping items. During the discussion, please mute yourself. If you have a question, feel free to type it in the questions chat box, and we will try to answer them as they come in. Close to the end of the discussion, we will open up the panel for more discussion and questions. At that point, feel free to unmute yourself and ask the question or just type it in the chat. For future webinars, we hold these every once a month, the second Friday of every month. And we would love for you to sign up for more. And we also have a bunch of other export webinars and trade missions and trade shows that we display and show on our events page. You can find that at www.edpnc.com and just click on the events tab, and that's where you can locate any more information about upcoming events that we will have in the future. At this time, I would like to introduce our speakers, attorneys Russ Racine and Charlie Raphun. They're with the North Carolina-based law firm Cranfill Sumner LLP. They help North Carolina companies understand trade-offs with respect to international patents, trademarks, and data privacy concerns. Their talk will include some stories and tough lessons learned, and they will ensure that the participants understand the realities of protections provided through these legal considerations. Russ Racine is a registered patent attorney and represents clients in all aspects of intellectual property, focusing primarily on litigation. He litigates cases related to patents, trademarks, copyrights, trade dress, and trade secrets. Russ routinely counsels clients on how best to obtain trademark registrations domestically and internationally, and how to deal with other parties who are infringing or about to infringe on his client's intellectual property. Charlie Raphun is a commercial and technology law attorney with over 25 years experience in the technology industry. He provides transactional services and pragmatic counsel to businesses for implementing compliance programs, managing intellectual property portfolios, and developing risk management systems. He is registered to practice before the U.S. Patent and Trademark Office and is also a North Carolina CPA. At this time, I would like to turn it over to Russ and Charlie to kick us off. Gentlemen.
Great. Blake, thank you very much, and it's a pleasure to be here. Just to give you kind of a subway into what we're going to be discussing today, what we're trying to do is present some high-level concepts involving intellectual property, and we're also going to, like Blake mentioned, we're going to give a few war stories. This is, in 1 hour, we're not going to make anyone an expert on international trade or international IP, but we're hopefully going to present some ideas that will help you with your businesses or with your clients or whatever industry you happen to be in. As part of that, I've had a number of years of managing intellectual property portfolios for several companies, and just again, I have some interesting war stories. Hopefully, you'll find them useful. Russ, can you want to discuss a little bit about what comes next?
Sure. Thanks, Charlie. Thanks, everybody, for being here. Like Charlie said, we're going to give kind of a 50,000-foot view of IP in international arenas. And part of what we're going to try to do is make you aware of some various issues you need to consider when exporting products to other countries or importing products from other countries. We're going to have a series of questions, some polls that you guys can answer. I think most of them are true, false. And then once we get a consensus on those, we're gonna answer the question and explain the answer. Some of the intellectual property types we're going to be discussing are patents, trademarks, trade secrets, copyrights, various licenses, and then some data privacy law concerns, which is becoming a very hot topic all over the world, quite frankly. basically, patents, for anyone who doesn't know, a patent protects an invention, and it's a public disclosure. So the people who look at it know what the invention is, but it gives you some protection for your invention. A trademark is a designation, an object, a visual aid that signifies the source of either the good or the service. A trade secret, most famous is Coke. It's their formula. Nobody knows it. They commercialize it, and it has value because it's not known. A copyright protects written works, audio-visual works. Basically, someone can't copy someone else's song. Licenses apply to all of those. And then data privacy laws, which are getting passed everywhere, relate to all that IP. And when you collect data from folks, they're designed to secure that data so it doesn't get into the hands of nefarious culprits who will then use it. So that's essentially what we're going to try to hit on. Charlie and I both like this topic, so we probably tend to talk too long. We're going to try to condense it into the hour. But again, if you have any questions, please put them in the chat. Let Blake know. Blake, do you want to maybe start us off with the first poll question?
Yep. You're right. We'll give it a few more seconds if everybody can try to answer that. All right. Hopefully we gave everybody enough time. Kelly, would you be able to pull that up? All right. So everybody looks like they said true. 57%.
Yeah. Well, that's a good, let me take remember, that's a good good sampling. I am impressed. I think the one, for those of you that said the answer is true, that's what I would view as the correct answer. A patent is, it's interesting ideas what a patent actually is. A patent is, it's basically a legal authority for the owner of the patent to exclude others from making, selling, copying that particular invention. And so in effect, it really is a monopoly. If it's a limited monopoly, monopolies have kind of a bad connotation, but in this context, this, at least in the US, for instance, the idea of a patent is embedded in the Constitution in Article 1, Section 1, Article 1, Section 8, Clause 8 is the legal authority for patents, and it even precedes the US Constitution. Patents are basically a government encouragement for people to invent things, and it gives you a limited right to exclude others from that invention. And what it does is, as a trade-off for getting a monopoly, you will have a limited period of time that you have exclusive rights to that invention, and it's roughly 20 years. There's some modifications to that, but roughly 20 years from when you file it. You have to disclose the invention formally at a certain point during the process of applying for the patent. That disclosure becomes public. So the trade-off of getting a patent is your invention gets known to the whole world, and others can create things that are improvements on it. Well, we'll talk about that later, but there are that's the significance of the monopoly. It's not an absolute monopoly. It's for a limited amount of time, limited scope, and you have to give a disclosure on it. I want to also just point out quickly, when you talk about IP rights related to patents, you don't necessarily have to have a patent in order to sell a product, but you need to have the legal rights to sell, make, or do certain things with that invention. So if you're not the patent holder, in theory, to protect yourself, you can try to make that product, try to sell it. If there are no patent holders, if there's no one that has the rights and the control of the monopoly on that product, you're probably, it's probably fair game. But if there is a patent on an invention and it's it truly controls that invention, then what you seek is a license, a written, well, it's an agreement from the owner of that patent to incorporate his or her ideas, concepts into the product that you're selling. So license is sort of like a parallel world with patent. Russ, do you have anything you want to?
Yeah, just briefly. So patents in the US, there's several things that are eligible for patent protection. The most common thing that everybody thinks about is an invention, a new device, a new tool or something. You can also get patents on plants. So for example, if you breed a new plant, you can get a plant patent. You can also get a design patent, which protects the look of, say, a chair. Also, you can get patents on drugs. You can get patents on chemical formulas. You can get patents on business methods. So for example, if you have a specific way you run your business, you might be able to get patent protection on that. Now, in terms of international law, the international laws of different countries related to patents differ. They try to protect inventions, but some countries have what they call industrial designs, and so you can get an industrial design patent in that country, and that will protect sort of like the design of a tool or something like that. Again, it is a monopoly, and as Charlie said, it's designed to promote invention and sort of reward you for creating this new invention, but it is tough to enforce patent rights in foreign countries. And over the years, it has been really difficult in the past. It's improving now thanks to international arbitration and things like that. But it is difficult, and depending on what foreign country you're talking about, I don't want to say it's impossible, but historically, for example, China has been very difficult to enforce patent laws, and China had a history of not respecting patent laws. That's improving. There's other countries. Russia currently is not doing very well with intellectual property, but the idea of a patent is to give you a monopoly with that particular invention wherever you are.
I do have a question about that, Russ and Charlie. Is there a quote unquote one-stop shop that you can get a patent for the entire world? And then I have another part to that question as well.
So there is not a simple one-stop shop, but there are patent treaties around the world that over time have become a lot more applicable. The Patent Cooperation Treaty is the main one that comes to mind, and that is it's not like you go to one place and you get a patent for the whole world, but it's a process for countries that have signed on to the Patent Cooperation Treaty. You have a limited amount of time if you want to register the patent that was granted in, let's say, the United States. You want to register it in another member's country. It's a somewhat streamlined process for doing it. It's not foolproof, but it does simplify things. Other things, think about, for instance, in Europe, the European Patent Office, each country in the European Union has their own patent office. So you could file in Germany and get a German patent and you're good to go. The European Patent Office is sort of the central, and I haven't filed any in the European Patent Office, except, well, I have filed them, but I have not done them only in the European Patent Office. But there is a somewhat streamlined process for filing in the European Patent Office and then registering that patent in France, Germany, Luxembourg, wherever. So there are some regional ways of doing that, but there is not a one-stop perfect patent covers the whole globe, though. And Russ, you agree with that?
No, I would just say that the PCT is the way to go if you're going to apply for a patent, because that gives you the ability to work with the U.S. Patent Office, and the PCT. You apply for the U.S. patent, you base your international application on the U.S. application, and oftentimes in a lot of foreign countries, they are sort of a Me Too jurisdiction. And so if you can get a patent in the U.S., a lot of other countries will say, well, okay, if you got it in the US, we'll go ahead and give you a patent in our country. And the PCT allows you to do that. And it's a lot less expensive to go through the PCT than it is to apply for patent protection in individual countries, especially if you're going to do more countries than 2 or 3.
Gotcha. We have another a comment or a question from Kathleen in the chat that asks, can you provide some comments on how filing with EPO interrelates with filing in individual countries such as Germany would be appreciated? So I believe, Charlie, you kind of touched on that.
Yeah.
But
yeah, that's so first of all, the PCT process is it still requires you to send your application to the different countries, but it's streamlined. It's got a uniform format, and it's a similar way of doing that. So there is not a way of just filing a patent just in one place that covers the whole world. So you do have to administer either country by country, except for Europe. You can administer that through the European Patent Office, and that will cover. That's where kind of like a one-stop shop for Europe, but
like covering all the US and all the states, you don't have to go to each state.
However, also one thing to be aware of it when you're filing patents overseas, you have to be mindful of the timing, because typically when you file a patent application, you have a certain amount of time. You make disclosures, and let's say you've published a white paper on a certain topic or an invention, and you know that came out 9 months ago. Well, you have a certain amount of time before, and that white paper becomes what they call prior art, and that means you have a certain amount of time. Usually in the US it's 1 year, but you have I don't know if it's different in other countries, but it's basically you have a certain amount of time that you have to file your application, or else it will become dated, because prior art that's more than 1 year, a certain amount of time before you file it, is going to be considered out there in the public domain. So that's one thing you have to be mindful of. If you start filing your application, let's say in Germany, and you go through the whole patent process, and you're not filing the PCT rules, and then you try to wait 5 years after that to file in the US, you're probably going to be prohibited from getting a US patent because of the prior art thing. So
one other brief comment about that. Also, if you want to file in the PCT, you can use a US-based attorney to file in the PCT. If you want to file directly in the German patent office, for example, you're going to have to hire a German patent attorney to do that, because US attorneys, unless they're admitted in the German patent office, aren't allowed to do that. So that's another, and attorneys are expensive. So that's another consideration to think about in filing a PCT.
Gotcha. A quick question I had: what's more prestigious? Which is a more prestigious patent, the utility patent or the design patent, or is it dependent upon what your product is and the use of it?
So that's a good question. The utility patent protects an invention. So something that you create, a device, something like that, and it lasts for 20 years. A design patent protects the look of something, and I can't remember if it lasts the same time or not. So they both offer sort of the same protection. It just depends on what you need to get patented. So for example, with a chair, if you've designed a chair and you have a novel way of connecting the legs to the chair that uses some kind of weird hinge or something, you could get a utility patent on that hinge. And so nobody could create the same hinge or an equivalent hinge, whereas a design patent only covers the look. So somebody could not create an identical chair, but they could still create chairs. So it's a different thing that's protected.
Cool, thank you.
Sure.
So I guess we can go on to the next poll question if you'd like.
Yes, let's do that.
Pull that up. Hey, if you own a patent on an invention, you automatically own the improvements to it. Ooh, this is a good question. I like this. It's a little learning time for me as well. I think I've only been to one of the Stop Fakes the IP Stop Fakes roadshow that the commercial service had put on, and it's a whole lot of information in a few hours. So
Yeah.
getting to hear it again is definitely very helpful. All right, unanimous. Wow. Unanimous. It's false. Is
All
this
right.
true?
So that's correct. It is false. You don't necessarily own improvements to an invention that is protected by a patent. So one of the things I wanted to do is explain briefly why that's the case. So a patent protects an invention, and you define that invention in what are called claims. And each claim has a specific element. So for example, if you have a pencil, you're claiming a piece of graphite or lead, you're claiming the shaft that encloses that, you're claiming the eraser. Each of those things are an element. So if you'll bear with me, I'm gonna try to show you a slide that actually created for something else, and hopefully will illustrate this. So hopefully you can see this. And what this illustrates on the right side is what is claimed as a widget, and it has 4 elements, A, B, C, and D. And so your patent on your widget covers elements A, B, C, and D, and would exclude anyone else from using a widget that has elements A, B, C, and D. On the left are 4 scenarios where an infringer would have a device. In the first one, that would have A, B, and C, and D. And so all 4 elements that meet your claims, that would be an infringement. The second one, their invention would have A, B, C, D, and E. Because they have all 4 of your elements, even though they have an extra one, they still infringe. Now, the third example, the other person has elements A, B, and C, but not D. So that's not an infringement, because in order to read on a patent or infringe, you have to have every single element in the claim. Now, the last example, a device would have A, C, D, E, F, G. Again, no infringement because there's no element B. So here's what I want to talk about. If you own an invention that has A, B, C, and D, and someone else comes along and they invent something similar, and it has element A, B, C, D, and E, so they've added something to your invention, they can get a patent on their invention by adding element E. All right. So you would not necessarily be able to prevent that, and you would not have any ownership in that invention. Now, here's the trick. That person who has A, B, C, D, and E, even though they would have a patent on A, B, C, D, and E, they would not be able to use it because they would infringe your patent. And so that element E, the improvement, while it may change the nature of the invention, it still does not give that person the right to use that invention. But it does not give you ownership interests in that new invention. So when you have a patent, you need to be careful, because somebody may want to make an improvement to that. And if they do, you don't necessarily own that, but you may have the right to prevent them from using it, even though they invented. So hopefully that made sense. Charlie, do you have anything to add to that?
Yeah, sometimes. So a lot of times the way businesses or companies get avoid this problem, if in an ideal world the two owners of the original patent and the new patent, you can negotiate what's called a cross license, so that you get a license to use each other's patents. And one might be paying royalties to the other, but that's typically how you kind of solve that dilemma. And so a cross license or a license to use that patent is the solution for that.
So we have a question. Somebody's asked if you have an international intellectual property, is there a country where you must patent? So that's a tough question to answer. And I think what you need to think about is, first of all, what is it that you have patented? And so let's say, for example, you have a new tool for woodworking or something, and you have a patent on this new tool and you want to market it and sell it overseas. You need to be familiar with the industry. And so, for example, in that scenario, what I would say is, and this is pretty much for any kind of invention, I would patent it in the US for sure. Because as I said earlier, a lot of countries are sort of Me Too countries. So patent it in the US. In terms of a tool, I would suggest Germany is probably a good one to get a patent, because Bosch is located there and they manufacture a lot of tools. You also might think about getting it in the European Union if you want to sell your tool in countries in the EU. Britain now, if you want to sell in England, you might think about Britain, and that's where the PCT comes in and really shines, because you can apply for patent protection in many different countries. So really the answer to that question is, there's no country that you really must get the patent in, but if you want to protect your invention, and you know where you're going to either sell it, where you're going to export it to, or where you're going to import it from, you probably should get a patent at least in that country. And if that country is in one of the sort of clearinghouse groups of patented countries, for example, the European Union, you might as well get the European Union patent so you're protected in all those countries.
Does it matter if it's first to use or first to file, depending on, each country's, I know the US is first to use, but most other countries around the world are first to file. Does that matter as far as wanting to obtain that patent internationally?
So that's a good question. And with respect to patents, as Charlie said earlier, you have a window. If you start using your invention, then you better jump on it and apply for patent protection. First to file versus first to use is really more of a trademark issue.
Okay, my apologies.
No, not a problem, but it is very important that as soon as you start using your invention, you need to talk to somebody quickly, because laws vary from country to country. Somebody asked a question about India and the patent process in India. And India is one of these countries that is always innovating and is sort of on the forefront of technology and things like that. So yes, I would say if you are thinking about selling in India or importing from India, and you can get a patent in India, it's well worth absolutely looking into.
Yeah, and I've had some experience with patents in India. I used to be an in-house attorney for a telecom manufacturer, and we did a lot of software, hardware systems that we would sell. And when we would sell, so for the patents that you register in India, you're doing so for a couple of, there are some countries that you're filing patents in, that we would file patents in, not necessarily because we were trying to protect the invention, but because we got certain trade benefits. For instance, we would get some tax breaks. There in China, for instance, there's an economic trade zone that we would get some tax credits, tax breaks, and additional incentives if we were able to actually get the equivalent of a Chinese patent. And so that was an active environment. India is it's one of these countries that is really trying hard to increase their, increase the inventiveness of the local economy, the inventors that are in India. So one thing that's interesting, if you file a patent in India, two things: if you have an Indian inventor, a resident, I'm not sure if it's a citizen or resident, but if you have an Indian inventor who is one of your inventors on a US patent, at some point in the process of getting a US patent, you have to file a patent application in India. Now, that doesn't mean you have to proceed all the way to getting the patent approved and finalized in India. You could stop work on it, but you have to do you do have to file initially within a certain amount of days or months in India if you have an Indian inventor. So that's because of some treaties we have. Secondly, with India, if you get a patent in India, you have an obligation every year to report there's a form you have to fill out that either acknowledges to the Indian government that you are actually making use of that patent. You're developing products and producing products sold in India related to that patent. So there's a little bit of interesting, I bring that up just to highlight some of the interesting little characteristics that go on. So hope that's helpful.
I think so. We don't have anything else coming in now, so I guess maybe we should jump on to the next poll question.
Yeah.
Is it illegal to sell a new product without a patent in a country? Couple more seconds, and I think everybody should be able to answer that one. All right. Looks like another unanimous.
Yep. Well, let me take this one. Actually, I consider this to be kind of a trick question. It's not an absolute yes or no. I think everyone that said no, that's probably generally the correct answer, because there's no. If someone already has a patent for your invention and it's identical to your product in that country they're trying to sell to, that person can exclude you. You can start trying to sell your product over there, but you're going to find yourself on the receiving end of a lawsuit. So is it illegal as far as a criminal law? No, probably not. Probably not. I don't think. But that if there is a patent holder, they can take action to exclude you. So that's why I say it's kind of a trick question. If there is no patent holder in that country for that invention, and your product incorporates, basically either what I call open source or open world, technology, but there's no patent on it, yeah, you can sell into that country. Just a quick note on exports versus imports. Generally speaking, and looking from a U.S. perspective, there's no requirement that you have a patent to do an export. Okay. To import into a country, then you have to look at the import laws of that country. You're not going to find any countries that say, legally you're required to have a patent for it, you can sell a product there. That just doesn't happen. But what you will find is some countries may question whether you have legitimate rights. And sometimes in the importing process with the customs agencies of whatever country you're trying to sell into, you may get pushback, especially in countries, Southeast Asia, some in the Middle East. It's not like it's always going to happen. It may be an occasional thing, but you might get this in trademark, similar thing. They may say, we want to see proof that this is your product, this is your technology, before we'll give you an import license. And so it's not truly a patent rule, but that's just a practical thing to keep in mind.
Is that something more like a certificate of free sale on an apostille that they have to acquire and then be able to, because that's something that we offer. Those are services that in Southeast Asia, there are, I would say it's more of the cosmetic and medical fields that require that certificate of free sale, basically saying that it is legally to be allowed to be sold here in the US.
It's related. Yeah, I think it's related. So when you talk about, when you're selling a product into a country, you need to have the right to sell. You need to have a bundle of rights. Those rights don't necessarily have to be patent ownership. They could be, if you didn't make the product, but you're a reseller of it, you should have license rights from the manufacturer. Manufacturer says in a contract, we authorize you to sell. And you get commitments from that manufacturer that they actually either own the patent or they in turn have the rights to sell. So you do need those in order to get some of those certificates. Sometimes you also will get requirements to have country of origin certification. And again, this is all import-export law, not patent law particularly, but having a patent help. Yeah.
Christopher, you mind muting yourself, please?
Anyway, Russ, any additional thoughts on that?
Yeah, so the other thing I would add is if you have a question whether you are going to get into trouble, exporting a product into a specific country, then presumably you have contacts in that country you're working with to receive your goods and then sell them. And so what I would suggest is, you need to discuss with your contacts in that country, hey, are you sure we can do this? Is everything okay? And you need to include provisions in your written contracts with those folks in the other countries that are designed to protect you in case they get it wrong. And you try to import your good into a specific country, and all of a sudden, you realize something's gone wrong, and the customs folks in that country sees your product at the border and won't let it in, and either destroy it or something. You need to protect yourself via contract with your contacts in that other country, just in case something happens. You can also rely on them somewhat to clue you into certain specific licenses or specific documentation you need to import your product into the country. But yeah, you don't necessarily have to have a patent on your product to get it into another country.
Awesome.
Wait, why don't we go to the next poll question?
Sounds good. I have a trademark in the US. Is it okay to use that mark anywhere else in the world? Kind of asked that earlier, but more focused on patents versus trademarks. So you might as well dive into some trademarks.
Just while we're waiting for the poll, I think in many cases, getting a trademark is, for most businesses, doing business overseas is probably almost more important than getting a patent, unless you're doing something really, high technology. So at least, again, that's just a practical view. It's not true for everybody, but that's my take.
You're right. Not unanimous here. So 64-6.
So I'll take this one. It's an interesting question, and I will say that it's almost a trick question. Having to choose between true or false, my inclination is that it is actually false, and here's why. If you have a trademark in the US, then you likely have a trademark registration through the US Patent and Trademark Office, and that gives you rights to that trademark in the US. But if you are exporting into a different country and you haven't checked, it is possible that somebody else owns the same trademark in the other country, and that happens more than you would think, actually. And so if you then try to export your product, even though it has your trademark on it, into that country, you would not have the rights to do that because you don't have the right to that trademark. I want to show you another slide briefly, because it's two things. I like the slide, and it shows a good issue that I want to highlight. So hopefully you can all see this, and it is a conglomeration of lots of trademarks. And I like this slide because A, it shows a bunch of different types of trademarks, and B, it shows a good thing that you need to be aware of. Now, I didn't create this slide. I stole it from somebody else. And if that person, this would be a copyright, but if they wanted to prove that I took this, they could. And I'll just ask a rhetorical question. Can anybody see in this slide how they would know I took it? I'll show you. If you look over at the top left at the fourth down, the Goodyear trademark, it's missing the G. And so that's not actually Goodyear's trademark because it's missing an important element. Now, here's why I point this out. There are companies and inventors and folks like that who will build in little protections like that into their IP such that they have an easier time proving that somebody took it. So I had a case once where my client came to me with a software program that he was going to copyright and attempt to get a patent on it. And as we were working on that, we got a letter from somebody saying, hey, you guys stole this computer software program. It's mine. You copied it. You can't have it. And so my client swore up and down, no, we wrote the software. We wrote the code. It's totally ours. These people are crazy. I don't know what they're talking about. Fine. So we looked into it. And as he filed a suit, and as this progressed, we got a copy of the code. And as we were going through the code, at line 10,587, there were some hidden messages built in where the accuser had written little notes to himself and to his family. And that was in the code. And so at that point, we realized that he was telling the truth. And my client had, in fact, copied the software from this guy. And so, that led to us stopping all the application processes and really taking a step back. And I bring that up because, you have to be careful about things like that. And if you are going to, export something, and if it's code or something like that, there are some steps you can take to further protect yourself beyond just licensing. The other thing I wanted to touch on is trademarks in the U.S. And foreign countries have different requirements. And I think it's important to talk about the trademarks for two reasons. One, if you already have a trademark and you're going to send it into a foreign country, you need to be aware of how good your trademark is. Or, and probably more importantly, if you don't have a trademark yet and you're going to create one, there's some things to consider. I'm going to share my screen again and show you a little graphic that will hopefully illustrate this. So hopefully you can see this now. This is a scale demonstrating the strength of trademarks. At the very bottom left, you have a generic. And so you are not allowed to get a trademark for a generic word. For example, food mart. If you have a store that's selling food, food mart won't cut it. If you're going to sell tennis shoes, shoes won't be a trademark. No country in the world allows generic terms to be used as trademarks for the terms they describe. Going up the scale, you have what are called descriptive terms, which would be quick print for a print shop, computer land if you're selling computers, things like that. You can, in the US and some countries, get trademark protection for descriptive terms, but there's a lot of extra steps you have to do. And my suggestion is these are very, very weak trademarks. In some countries, you won't get them. They don't recognize them. So you need to move up the scale at least to suggestive and arbitrary. Now, suggestive are pretty close to descriptive. Again, I would say try to move up the scale. Arbitrary are good, strong trademarks. They are Apple computers. Apple is an actual thing, but has nothing to do with computers. So that's a strong trademark. Shell gas. Shell has nothing to do with gas. The fact that they're using it as a trademark for gas is good. It's strong. The strongest trademarks are what are called fanciful or arbitrary. That's made up words. Exxon, Kodak, Xerox, Buick. Those are all made up words that companies have adopted as trademarks. Those are very, very strong. And those are strong in every country that recognizes trademark rights. Those are your best bet. But if your trademark is too good, you end up in the trademark graveyard. Now, I like this slide because it illustrates what happens if your trademark is so good that it becomes the generic term for whatever it is you're selling. So, for example, aspirin. Yes. That's salicylic acid. But because everyone called aspirin, now that is a generic term and they lost the trademark. Zipper is another one. I didn't realize that, but zipper was actually a trademark. Nobody calls it intermeshing teeth Everybody calls it a zipper, so they lost that trademark. My point is here that if your trademark is really, really strong, then that's great. But if it's so strong, it becomes the generic term, then you're going to lose it. And that's true in almost every country. The issue with exports is if you have a patent, say on a tool or something, and you use a trademark with that novel invention that's not out there yet, you run the risk of that trademark becoming the generic term for that article. So be sure that nobody owns your trademark in the country into which you are exporting your trademarked product. You can do searches of their trademark databases to make sure if it's a new trademark you've come up with. There are still ways to use descriptive words to search for that trademark. So be careful when you are exporting to foreign countries. Just make sure that the mark you're using is not owned by someone else in that country and that you have the right to do it. Charlie, do you have anything else?
Just in enforcing, it's important to enforce your trademarks. One of the best ways to, you can't totally prohibit it, but if you can minimize the risk of someone having of your trademark or your brand becoming the zipper scenario. You whenever you get wind of someone who's misappropriating or using your trademark against your wishes, and in a country you have a registration, you send them a cease and desist letter. You take legal action as soon as you can. One thing companies ought to do, especially if you have a brand or a trademark, or even if it's not registered, but if you have a mark that it's really important to you, specifically your company name. Sign up with a trademark attorney who can do what's called a watch list, and it usually doesn't cost a lot of money, but they do monitoring all over the globe. And whenever something pops up, whether it's in commerce and some kind of website, if these watch lists do a real good job of highlighting and spotting cases where someone is starting to use your trademark or something similar to your trademark. And that allows you to decide whether you want to take action and protect your brand. So that's something to think about. Okay.
One thing I forgot to mention, and Blake, you brought it up earlier, your question of first to use versus first to file. So that applies to trademarks, and here's how it works. In the United States, trademark rights attach as soon as you start using your mark. So if you start selling a product with a specific trademark you've created, you immediately get certain rights to that trademark. All right. And so in the US is a first to use jurisdiction, which means whoever uses the mark first gets superior rights, other considerations aside. Most countries in the rest of the world are first to file, which means you don't have to use the mark before you acquire rights to that mark. One more time, I'm going to show a screen, and this is just a list of first to use versus first to file countries. So if you are exporting into a first to file country, you want to go ahead and register your trademark with that country before you export to it. Because if you don't, if you send your product into that country with your trademark on it, somebody else may say, hey, I like that trademark, I'm going to register it here. And because we're a first to file country, they would get rights to that trademark. If you look at this list, there's a couple of countries I want to point out. So first to use, United States. So we're a first to use, but Mexico is a first to file. And so if you want to import into Mexico, you better go register your trademark with Mexico before you do so. Also, the UK is a first to file. The European Union is a first to file. So again, the US is sort of an outlier because they're a first to use, but you want to be very, very careful in other countries, because if they are a first to file, you want to go ahead and file your mark. There's a question in the chat that says, is it recommended to file for patents in other countries for a product that's already been manufactured in the US for decades? It's probably not going to be, you're not going to be able to get a patent in another country if the product has existed for a long time in the US. As Charlie alluded to earlier, there are time limits on when you can get a patent. Now, there may be other ways to protect a product like that, one of which could be through a trademark. But if you've been manufacturing a product for a significant time, you're probably not going to be able to get a patent in really any country, depending on the time that product's been used.
We got a few minutes left. We might go about 5 minutes over 11 o'clock, if that's all right with you all, and just out of respect for everybody's time. I have a question that's kind of pertinent to right now with everything going on with OpenAI and AI being released and unveiled by everybody. If AI writes code, who owns that code? Charlie or Russ? I mean, who is the owner if you have AI write it and it's not your code that you write? So who can you complain against?
Yeah, so the generic answer is the invention has to be done by a human, but there are some questions about, well, a human had to have written the code that generated the AI generating of code. So when did actually that process begin? So, I think
that's at the algorithm. Is it like when?
But that's my understanding of the scenario. I mean,
yeah, I think it's too new to even have an answer. So,
and that's an excellent point, because as that continues to come up and AI gets more advanced, aside from killing everybody, I mean, y'all saw Terminator, right? Aside from that, there's going to be questions exactly on that. And I haven't seen any court cases come up yet, at least in the US. But that is a great question. And the same thing applies even to like copyrights, for example. So if you have AI generating music or generating something like that, there is going to be litigation involving who owns what. So that's a great question, and unfortunately, we don't have really an answer.
No answer yet.
Yeah,
wait for the courts.
Exactly.
We do have one more question that just came in. Is the difference on process considered enough to patent a new product or require components change?
So that's a great question too. So it would, and the answer is typical lawyer answer, but it depends. And it depends on how different the change is to the process. So for example, if you have a business method patent that is a method of doing business, and you come up with a different step that you would plug into that method, depending on how different that step is from the patented steps, it may be eligible for a new patent. Now, again, going back to the elements, even though it's a new step and may be eligible for another patent, it may not give you the right to use that method absent permission from the original patent owner. So I would say you will need to discuss that with a patent attorney who will be able to look at the change and make some recommendation on, yes, this is different enough. No, it isn't.
All right, well, why don't we go ahead to that last poll question in the interest of time? Kelly, that's it. All right, having a trademark can be helpful in being able to import goods in a country. True or false? All right, why don't we go ahead and pull up that got a couple people that said false. Let's discuss.
Yep. So I think that's a pretty correct. I think true is the right answer. Is it essential? I would say, not necessarily essential. It's helpful, and let me explain why. Getting aside from whether you have to have a trademark, whether if you decide you need to register it for whatever reason, just to protect your brand, setting that aside for a moment. There are many countries, and I won't say a lot of them in Europe and US and North America, I'm kind of excluding that, but there are a lot of countries, particularly in some of the lesser developed countries, where they're very concerned about counterfeit goods coming in. And so they take precautions in their as part of their import process, going through their version of customs to make sure they're not importing counterfeit goods. And so having a trademark, being able to demonstrate to the customs agents that you have a trademark gives you a lot of a lower risk of those goods being impounded, because it's just helpful. It's not in their law, it's not mandatory, but that's one thing I found. The other aspect of it is, if you're a lot of times you might need a trademark in that country in order to put signs on your offices, on your buildings over there. Signs like, let's say the name of your company, Acme Printing, and you want to open up a shop. This is a very good example, because India, I've had to have trademark registrations for our company's name, simply because we want to put signs on our building and on our letterhead and that sort of thing. So it's important to do that. That's one good reason to get a trademark in certain countries. India comes to mind particularly. So anyway, that's all I have on that one. Hope that's helpful.
Gotcha.
There is one other concern too, and I know we're out of time, but just real briefly, there's a issue called gray market. And what that refers to is when you sell a trademark good somewhere, and the person who buys your trademark good then turns around and tries to sell that, or turns around and tries to import that into a different country. Those are gray market goods, and there's a lot of differing laws and regulations regarding that type of product. And so if you are the owner of a trademark, you may have rights to control some of that gray market. You may not. It depends on the country, but it's always more advantageous to have a trademark on your goods or associated with your services than not.
Awesome. Well, gentlemen, thank you. Oh, Charlie, do you have something else?
No, I think that's all on this one. This has been a good. Hope it's been helpful.
Yeah, no, this has been a great discussion. If anybody has a final question, get it in real quick. I'm just going to give the gentleman an opportunity to plug themselves. If anybody has any questions or would like to reach out to use the services of Charlie and Russ, gentlemen, please provide your email addresses. I believe we have that on an upcoming slide, but obviously they're at Cranfill and Sumner, and you can get in touch with them there. And I believe that's it. I don't see any other questions coming in at the moment. So with that being the case, anybody want to ask a question? You can unmute yourself real quick.
And if you want to ask, privately, that's fine too. Here's my email. I'll put it in the chat. Feel free to email a question. I mean, this it's a fun topic, but exporting into foreign countries is a minefield, and there are some good solid steps you can take to protect yourself. Your written contract with your contacts in the foreign country is your first line of defense, and I can't stress enough how important it is that contract be written and have the terms you need to protect yourself, protect your products. Again, thanks everybody for being here. If y'all have questions, please reach out.
Blake,
happy to answer.
Blake?
Yes.
Hello? Yeah,
hello,
this is Simon. How are you?
Good. How are you?
Thanks. This has been a very, very good session, man. Very informative, man. So
thank you very much.
Yeah, I really appreciate you and the team here, the girls that are presenting.
Yeah.
My question is, will this recording be made available and some slides be made available to us?
Yes.
Okay.
Yeah,
great.
we're going to.
I would love to watch it again.
Yeah, definitely. Well, after this happens, I think tomorrow or in a few hours, we will send out the recording to everybody that has attended or signed up. Okay. So you'll be able to rewatch it again and review it. And then I believe I did see their email addresses on some of the slides. Russ has put his email address in here, and I would assume Charlie is Raphun at cshLaw.com. So his first initial.
If you could include their emails in when you share the recording as well,
Yeah, we can definitely look into that.
That'd
Simon.
be great. Yes, this is good. Thank you all. Yeah,
You're very welcome. Thank you.
Well, thanks
All right.
everybody for attending. We really appreciate it.
Yeah, no, this has been a great discussion. It's been fun, and hope everybody's morning is off to a good start, nice and energized with some extra coffee. And we look forward to seeing everybody next month at our next coffee talk. Thank you very much for attending, and go to our website, edpnc.com/events to find out what the next upcoming webinar and coffee talk is going to be, and you can register there. But in the meantime, thank you all very much. Have a great weekend and enjoy the beautiful weather out there.
All right.